Good morning, everyone. It is December 15th, and this is the Land Use Meeting Process Workshop. And I'll call the meeting to order and ask for a roll call, given the meeting is virtually attended today.
Good morning, Overman.
Here.
Cohen? Cohen? Hagen?
Here.
Kemp? Kemp? Myers?
Here.
Smith?
Here.
White?
Here.
Thank you. You have a quorum.
Excellent. Thank you very much. And with that, we'll go to the meeting process, and Adam Gormly will be doing our presentation there. Adam?
Thank you, Commissioner, Chair Overman. Good morning, Adam Gormly, Hillsborough County Development Services. I've got a presentation that I'm going to run through for today's workshop. This presentation will focus on the land use meeting process and primarily focus on rezoning items, which are the items that the board spends the most time on in the land use meeting, and are the ones that are the types of applications that have, I'd say, the most process discussion items. So with that, I'm going to move to PowerPoint presentation. Can everybody see the PowerPoint on the screen?
Yes, we can.
Thank you. So this workshop will be on the land use meeting process. So the board BOCC land use meetings are held once a month, primarily to include land use related matters. The items that the board has on their land use agenda include rezoning applications, modification to planned development zonings, acceptance of final plats, acceptance of development provided infrastructure, things such as utility lines and road improvements that the county will accept and maintain, and requests to vacate rights of way and or plats. So I'm going to go through the different types of zoning districts. I know many of you are familiar with this, but just a little context setting. We have a couple of different zoning districts. One of them is the standard Euclidean district. And these are districts that are set out in the Hillsborough County Land Development Code. They are applicable potentially throughout the county. Of course, each zoning district needs to be consistent with the adopted comprehensive plan and future land use category, but the districts are not unique to any one particular property. The districts permit a defined set of uses, and those are set out in the land development code for each of the zoning districts. And those uses are either permitted, conditional uses, or special uses. A permitted use simply is a use that's allowed, subject to typical site development permitting. A conditional use is also a use that is allowed, but has additional performance standards that need to be met for the use. And a special use is a potentially permitted use in a district, subject to a special use hearing process that would consider, amongst other things, the compatibility with the use for the particular location where it's sought. The standard districts all have performance standards that are set out in the Land Development Code. These include setbacks, minimum lot sizes, maximum height, and it basically lays out how development needs to conform to the parcel on which it's proposed. Standard Euclidean districts do not have conditions per se, but there is the opportunity for placing restrictions on standard zoning districts subject to the agreement of the applicant property owner. And these are a little bit different than the plan development conditions, which I'll get to in a second. But these restrictions do actually have to restrict uses further than what the code allows. It's not a vehicle to allow more than what the district otherwise permits for standard districts. The other type of zoning district that we have is a plan development zoning district. Each plan development district is unique and customized for a single site. The plan development zonings are subject to a general site plan and conditions of zoning that will control the development of the site. Sometimes those conditions of zoning may reference standard district uses and our performance standards. Other times they can be used to accommodate a single or limited scope of uses, or they can be used to permit uses that are not defined in the land development code and are more unique than the standard uses that are listed for the standard zoning districts. Process-wise, plan development zonings, when there's a new request filed for a new plan development, there is a requirement that if the people receiving notice of the application, any person who receives that notice requests the applicant hold a neighborhood meeting, then that's something that the applicant will be required to do. They will hold a noticed hearing and provide a sign-in sheet and notes summarizing the items discussed at the meeting. And the idea with that is to, since plan developments are unique, potentially unique, and a customized district, the neighborhood meeting is intended to familiarize those around the project with it, and to provide an opportunity for any feedback and potential refinement of the project in the event that it poses elements that may need some refinement to be compatible with the area. Plan development zoning districts can be modified once approved, and the process for modifying the district will depend on the scope of the modification. That's what I'll speak to in just a minute. So I know the board discussed yesterday the items on the agenda, the E items, which were the minor modification public hearings, and as opposed to the F items, the regular rezonings. And the difference in those processes, and I'll get into that a little bit more in the presentation, to say that when a plan development is going to be a new plan development or a major modification to a plan development, both require a hearing before the zoning hearing master. Minor modifications to plan development zonings are a public hearing directly, immediately to the board without a zoning hearing master public hearing being held first. So what are major and minor modifications to existing plan developments? So if any land is going to be added to an existing plan development, that is a new rezoning application. Major modifications, and again, these are the ones that go to the zoning hearing master first before coming to the board, generally relate to adding a new use to the PD or increases in density or square footage for non-residential uses, density greater than 5% and square footage greater than 3%. And on the adding of the new use, the way that is structured is if a plan development may permit a use in a certain portion of the plan development, but not others, and that movement or allowance for a greater area of that use does fall within a minor modification. But if a use is just wholly not allowed within a PD, that's when it becomes a major modification. Minor modifications typically will involve changes to the plan development conditions of zonings, increases in density equal to or less than 5%, or changes in square footage of non-residential development equal to or less than 3%. The others you might see are changes to internal access and circulation, or the addition or deletion of access points. Their third change, there is an opportunity for administrative modifications to plan development zonings. These are very limited scope of what can be done administratively, but the main uses are if a use on the site is going to be relocated within the site greater than 500 feet from the PD boundary, that's something that can be changed administratively, or a reduction of up to 10% in excess parking. So it's not a reduction in the required parking, but a reduction of up to 10% in a excess parking that's provided. The other administrative change available is the conversion of multifamily residential to single-family residential. So the zoning hearing master process, again, this is the process that applies to new rezonings, either standard or plan development, standard district, plan development district, or major modifications to plan developments. These hearings are conducted by a land use hearing officer. That land use hearing officer is appointed by the Board of County Commissioners. The zoning hearing master hearings are held in the evening, typically on a Monday at 6 p.m. and it is a open hearing. There's no limitation on what evidence or information can be presented into the record or who can present that testimony. The purpose of the zoning hearing master is to establish the record for any particular application for consideration by the Board of County Commissioners, and the ZHM will hold a public hearing, consider the evidence and testimony provided, and then render a recommendation to the board on each application. So again, the conduct of the public hearing, these are noticed public hearings for the ZHM hearing. They're noticed through mailed notice to surrounding property owners, a sign posting on the site, and a legal advertisement that's published in newspaper. The hearing master is presented with a staff report from the Development Services Department. This staff report incorporates reviewing agency comments that the county has or the department has received, and summarizes findings and recommendations on application and any applicable conditions in the case of a plan development rezoning. Note that as was the case for a couple applications on yesterday's land use meeting, if the department is not recommending support of an application, we of course don't recommend conditions of approval. However, we do typically make the applicant aware that it would be to their benefit that if they have proposed conditions to provide those in the event their application is approved, the conditions are already ready. We do work with applicants on those situations to, notwithstanding any non-support, ensure that the conditions that they're submitting can work in the event the board would approve the application. And by that I mean that it covers the elements that would typically need regulated by the conditions, and that they are structured in a way that is enforceable. The other information that the zoning hearing master gets is gets a staff report from the Planning Commission staff, And this report outlines the points of compliance or non-compliance with the comprehensive plan. This includes the consideration of the uses and intensities allowed in the future land use category that's applicable to the property, other applicable goals, objectives, or policies within the comprehensive plan, and any community planning issues that are relevant to the application. The hearing master also has available correspondence and evidence received before the hearing and submitted to the master file. So for each application, we keep a master file which includes correspondence, evidence submitted in advance of the zoning hearing master hearing, and those are that's part of the backup that goes to the zoning hearing master. When the hearing is open for each application, the hearing master will also take any additional evidence or testimony that's provided by the public or the applicant or any interested person at the hearing. And as I mentioned earlier, at the conclusion of the hearing will close, and the zoning hearing master will generate a recommendation, render a recommendation to the board, which is filed 15 working days after the close of the zoning hearing master public hearing. And the purpose of that time is there's sometimes a lot of information and material that's in the record, so it gives time for the hearing master to go through that material and render a recommendation to the board. That recommendation does include and is required to include findings of fact, conclusions of law, and findings of any points of compliance or non-compliance with the comprehensive plan. Once that recommendation is filed, the board considers them at their land use meeting. The rezonings are either on a consent or regular portion of the agenda. It's a recent discussion about the consent agenda. Where we are currently is that to go on the consent agenda, an application must have all recommendations of approval, and that's from the Development Services Department, the Planning Commission staff, and the zoning hearing master. If any one of those is different than the others, it doesn't go on the consent agenda, or if they're all for denial, they also do not go on the consent agenda. The other criteria for being part of the consent is that an application have no prior participation prior to the zoning hearing master public hearing or at the public hearing. So meaning no evidence is submitted to the master file in advance of the ZHM public hearing, and nobody but the applicant spoke or presented any evidence at the zoning hearing master public hearing. The other two factors that need to be met to be on the consent is that the application does not represent a density increase in the rural service area, and it is not located on a failing road. Once the board gets the application, what the board is actually considering, the way the land development code is structured, is the board considers the ZHM recommendation and the record established at the ZHM public hearing, including the ZHM, a transcript of the hearing. So while there are three different recommendations that are going to the board from Development Services, Planning Commission, and Zoning Hearing Master, the way it's structured is the Zoning Hearing Master recommendation is what the board is actually considering and acting on. That's why in prior to changing the consent criteria, when an application was on consent that had all denials and the board moved to approve that, they're approving that Zoning Hearing Master recommendation of denial. There are some opportunities for participation at the board hearing, one of which is potential for an additional evidence request. So again, the board is limited at this point for rezoning applications, major modifications, and new PDs to the record established at the zoning hearing master hearing. However, if any party feels that there's additional evidence that needs to be considered that's relevant to the application, and this is the key part, that could not have been presented at the zoning hearing master hearing, then the board can approve, if those criteria are met, the board can approve the additional evidence request, and one of two things will happen in that case. One is that the application gets remanded back to the zoning hearing master to consider that additional evidence, or the applicant can waive any objection to the inclusion of that additional evidence in the record, and the board can proceed to consider the application with that additional evidence. I will note that while the opportunity is there to provide additional evidence, the standard for providing that the bar is fairly high, and it is very rare that or additional evidence request is actually granted. I don't know that we've had any with this board. I can only think of a couple times where the criteria of could not have been presented at the hearing was met. At the board hearing, there is also the opportunity for oral argument to be presented by parties of record for items on the regular agenda. And this process was recently changed by the board. Previously, there was a requirement that any party wanting to file oral argument needed to present oral argument needed to file a request to present that oral argument before the board. That filing request portion has been removed from the code, so there is no longer a filing requirement, and the way that the code is structured is any party of record can present oral argument before the board on a regular agenda item. That oral argument is limited to the record of the zoning hearing master hearing, consistent with what the board is structured to consider. And so what is a party of record? Party of record is somebody who had received mailed notice of the zoning hearing master public hearing and or presented evidence or testimony at the zoning hearing master public hearing either in person or by proxy, meaning somebody appeared and presented evidence on that person's behalf. And the third way to become a party of record is submitting documentary evidence into the master file for the zoning at least 2 business days prior to the zoning hearing master public hearing. So the board's action is, after considering the CHM recommendation, any oral argument, the board will act to approve or deny the rezoning application by resolution, and that resolution action is what generates the requirement to have 4 affirmative votes to dispose of the application, since it takes 4 votes to approve a resolution. The resolution would lay out all points of compliance or non-compliance with the comprehensive plan, if different from the zoning hearing master recommendation, and the specific reasons for the decision. So again, the board is considering the zoning hearing master recommendation. The board acts on that as presented, then that recommendation will be packaged to have findings of fact, conclusions of law, statement of compliance with the comprehensive plan, which the board would adopt. In the event there's an action different than the zoning hearing master recommendation, then the reason for that difference should be noted in the resolution that's affecting the either approval or denial of the rezoning. The board does have the opportunity, when considering the recommendation and record of a zoning application, to remand an application back to the zoning hearing master. And this opportunity is there if the board feels that additional information or analysis is required in order to position the board to make a decision on the application. So that's the rezoning major modification, new plan development process, the two-step process that has the zoning hearing master and then Board of County Commissioner review. The other type of application, rezoning application that the board would consider are minor modifications. These are the ones with the PRS prefix, and these are the E items on the land use agenda. These are public hearings directly held by the Board of County Commissioners. These are noticed public hearings. They're noticed through mailed notice and sign postings on the site. I will note that for minor modifications, one of the things that's different from those than rezonings or major modifications is there's no new uses on the site. So when we're dealing with a minor modification, the applications are essentially dealing with the arrangement of uses on the site and to a small degree the scope of the amount of those uses, but the amount part is pretty limited. The Development Services Department also prepares a staff report for minor modifications. These will set out findings and recommendations, and again conditions if it's supported. When there's a minor modification, that there most times will be changes to the conditions, and those are presented in a strike through and underline form to show how the application is proposed to be changed. While not set out as a requirement in the code, if it's applicable, there will be a Planning Commission staff report filed that'll outline the points of compliance or non-compliance with the comprehensive plan. Again, minor modifications are typically rearrangement of uses on the site. So it doesn't necessarily, all of them don't necessarily implicate comprehensive plan considerations, but certain ones do. And we had one on the land use agenda yesterday where there was a comprehensive plan issue that was identified with a minor modification, and so a Planning Commission staff report was included for that application. Just like rezonings, correspondence and evidence can be submitted into the master file for each application in advance of the hearing. It's part of the record that the board would consider, as well as any evidence or testimony provided at the public hearing. And again, these are open public hearings for minor modifications. There is no limitation on who can speak or what evidence can be presented. Of course, the consideration is to evidence or testimony that's relevant to the application, but there is no pre-screening of what can be said or limitation to a previously established record. And at the conclusion of the public hearing, the Board of County Commissioners acts to either approve or deny the application by resolution. I hit on a couple elements for the basis of the Board of County Commissioners' decisions and ex parte communications. I'll hit on this generally. Johanna Lundgren is also available to go into a little bit more on due process considerations with land use decisions. But essentially, so decisions on rezoning applications and plan development modifications are considered quasi-judicial actions. And that means that the board is applying a fact set to an established set of rules or criteria and making a determination of whether those are met. So a rezoning application is evaluated against the land development code, the comprehensive plan, and the requirements and direction that they contain, and makes a determination of whether those are met. The decision does need to be supported by competent, substantial evidence that's contained in the record for each application. So again, the record, the master file that is considered, that is established for each application, that is the information that's presented into the record in advance of any public hearing or at the public hearing, including the ZHM recommendation and transcript, if applicable. That is the body of evidence that if a decision is looked at and to see whether it is appropriately made, the information against which the decision will be measured would be that's in the record. Florida law does require that quasi-judicial decisions must be consistent with due process requirements, and I'll ask Johanna to speak a little bit on that in just a moment, as well as the next slide here, which will deal with ex parte. Sorry, dang it. Well, up to the end. Sorry, my apologies. So ex parte communications, you all have been advised that for pending zoning applications, should refrain from having discussions with people regarding that pending zoning application outside of the hearing process. Generally, that is what's called ex parte communication, and based on case law, ex parte communications are deemed to be or presumed to be prejudicial to quasi-judicial proceedings and may violate due process rights of interested parties. There is a statute that does allow for adoption of an ordinance that would lift or remove the presumption of prejudice and provide some procedures that would be required in that for disclosure of that communication or inclusion of that material into the record. That concludes my presentation here. I'm going to just ask Johanna if she would expound on the due process considerations that are associated with quasi-judicial proceedings, and it will be available for any questions, comments, and look forward to having some dialogue and feedback from the board on this process.
Adam, thank you very much for that presentation, and now I recognized Johanna Lundgren in just a second, but what I wanted to also share with the rest of those that are watching this presentation, that Commissioner Kemp and Cohen did join us about 3 slides in. So I wanted for the record to make sure that they were acknowledged that they were here and heard your presentation. With that, I'll recognize...
Madam Chair, before you go to Ms. Lundgren, I have my hand raised.
Oh, I now see that. I'm so sorry, sir. Yes, you're recognized.
Okay, give me just a moment here. Adam, will you go back to slides 13 and 14, preferably in reverse order, 14 first?
Yes. Can you see slide 14?
Yes, I can. Has the board adopted the ordinance or resolution that's allowed in section 286.0115?
Commissioner, no, the board has not. So
okay.
Yes.
I've heard of other jurisdictions that have a process that would lead me to believe that they have adopted an ordinance or resolution allowed per this section of Florida statutes. That's something I've been talking about for quite some time. Mm-hmm. If we stick with a quasi-judicial process, which I'm going to get into in a moment when we go back to slide 13, I would like to see the board adopt this ordinance or resolution. I'd love to hear my colleagues' thoughts on that, to see if there are at least 4 of us that would like to do so, but that's something I would be very interested in. And Adam, if you can go back to slide 13. So I'm looking and thinking about or questioning how bullet points 1 and 3 interact with each other. So Florida law requires that hearings on quasi-judicial decisions must be consistent with due process requirements. Bullet point number 1 says decisions of the BOCC on rezoning applications and PD modification applications are quasi-judicial actions. Is the county commission required to have a quasi-judicial process, or can we have a process that looks more legislative in nature?
No, commissioners, and I'll let Johanna expand. Now, the short answer is no, that
Okay.
rezoning applications are by law, are quasi-judicial processes. So it's not
Okay.
the board that establishes that as a quasi-judicial process.
So it's state law, case law, all of the above?
Yes.
Okay. So with that being said, going back to slide 14, I would be very interested in adopting this ordinance or resolution that would at least allow us a more open process for hearing from constituents, perhaps going out into a community meeting if that would be allowed. And then, obviously I know there would be some, if we were to adopt this, some disclosure requirement that would just, place it on the record that a commissioner had been out to hear from the community. That goes for other stakeholders as well, by the way. The applicants and their teams, presumably it would allow them to be able to speak with the commissioner as long as it's properly disclosed. But I'd like to hear more about that. And if there's interest on the board's part, I'd certainly like to consider adopting such an ordinance or resolution.
Interesting. Commissioner Smith, you're recognized.
Thank you. I'm not sure if I can run my video at the same time I'm speaking. Let me know, because my internet is a little faulty today. But Commissioner White, ever since you mentioned that at a land, I don't know which meeting it was, I have been thinking about that a lot. I mean, my first thought is, oh my goodness, this ex parte stuff was put in place back when the county had several commissioners led away in handcuffs for accepting bribes, for talking about zonings and making deals about zonings behind closed doors. What would be the unintended consequences?
Commissioner Smith,
two things.
Commissioner Smith, you are breaking up. Would you mind? Yeah, thank you.
Okay.
Because that way, I don't want to miss
Let's
what you're saying. So thank you.
All right, let's try it this way. Can you hear me now?
It's still a little rough, but I think it'll be better.
All right. Anyway, I understand the reason why ex parte was put in place was, to help safeguard against conversations about land use behind closed doors, and making deals about land use with the commission in the Bomer days, office days. But I think since then, the process has actually kind of evolved so that developers have learned how, and they commonly do, circumvent the ex parte restrictions by talking to commissioners about a rezoning before they file. So this loophole allows the applicant to work around the whole point of keeping communications limited to the public hearing by talking to commissioners before they've legally filed. And it gives the applicant an unfair access to the elected officials that the general public does not have. Because of that, I've made it my policy not to have those discussions, because I don't think it is fair to allow just the applicant and not the community to have conversations with their elected officials on a point that is, essentially insider information that the developer has that the community doesn't. But, what I have come around to is thinking that it might be better if everybody has that level playing field, and when the yellow signs go up and the notice is filed, the doors are open and everybody can talk to anybody about a zoning matter that may or may not come to the board. And, when you look at our land use hearings, where we've got, 10 minutes to hear from the applicant and 15 minutes to hear, or 10 minutes to hear from the citizens, there are sometimes cases where it could help us be more prepared and help the community have more time to really understand our positions and the stuff that's happening to them. So, I have asked a bunch of people about this and been thinking about this, and I think it is definitely worth exploring and trying, keeping in mind that anything we change can always be changed back. So if we find that it's, really problematic and it's leading to any kinds of complexities, we can easily or just as easily change it back the other way as we changed it forward. I would like to try having more information from everybody outside that ex parte communication. I have more I want to talk about, but I see other hands raised, and I'll come in back later for some other issues I hope we can consider improving upon. Thanks.
Thank you, Commissioner Smith. Commissioner Kemp, you're recognized.
Thank you. Yes, this was, thank you, Commissioner White and Commissioner Smith, all good points. This was on my list too, and I had my notes ready to go when, I was waiting for the presentation. I was wondering, Commissioner White, if this was the slide you were referring to. I know I've watched other meetings in other places, and, the board disclosed that they had spoken to this person or that person, and I heard it was that they had operated differently. We operate in this really unique universe, from anything I can tell, with regards to other counties and other jurisdictions. And I would be very much in favor of looking at, well, I guess I wrote down the statute number, 286.0115, removing the presumption of prejudice if adopted, because I do think the applicants, and I was kind of counseled when I began that, I shouldn't take the appointments of applicants before the application is filed, in all fairness to the community. And so I haven't done so, but I realize that that has been a regular practice for some commissioners in the past. And I really, while it educates, in some ways it's, it educates you about what it is there. And as Commissioner Smith says, you have very little time if you just learn about it right at the meetings to kind of process and understand all the elements. And then there's these time limitations. And for some of these issues, it's quite big, and there's a lot to consider. And I think it would be helpful. The other thing, it's so, and I understand why it's so, this process that we've had has been so difficult for the public, but it's certainly, it is incomprehensible a lot of times to the public, especially if they've dealt with other places, that they're not allowed to talk to their commissioner about maybe the thing that is most important to them that they've ever had dealing, where a commissioner could make a difference in what they cared about. And the fact that, well, we can't talk to you about this issue, I think I understand why they have why people have difficulty with this. So I mean, I don't even know if there's any other jurisdictions that do it the way that we do it now. But I am more than willing to move out of this. And as Commissioner Smith said, it could be a trial run, but it seems like this is the way the rest of the world does it. So I have a feeling, just like when we dropped the requirements that the filings to speak at our hearings, we make, not only is it already intimidating for people to come to talk at any of these meetings or to get engaged, but we have rules that make it, I'm just amazed anybody survives the process to speak to us, quite honestly, or has in the past. And I would really like to open that up, and I think it's important for us to do that.
Thank you, Commissioner Kemp. Commissioner Cohen, you're recognized.
I think that we should tread very, very lightly on this. I definitely understand the points that everyone is making, but there are some real abuses that could take place if you had a process where it were sort of Katie bar the door and anybody could talk to anybody about anything. What Commissioner Kemp just said is absolutely true. There's a real difficulty for people in understanding that they can't talk to their elected official directly about a matter that concerns them. It can be very, very frustrating for people in these quasi-judicial matters. And on city council and land use matters, we always had this rule, and you do labor under it in that sense. But the other side of it is that, quite honestly, I think it protects the decision makers. I think it gives you a level of protection about being improperly influenced. You can just lay down the law that you're not allowed to talk about these things carte blanche, and it cuts off it cuts off the improper influence. So, I'm definitely interested in hearing what everyone has to say, but I am very, very reluctant to tinker with this. I think that we might open up a can of worms that we don't necessarily expect. And we've seen in the past that that not having these rules can be really a way of having increased corruption in the system. So I just would urge everybody to tread lightly on this.
Thank you, Commissioner Cohen. I have 3 hands raised: Joseph Harless, Commissioner Kemp, and Commissioner Cohen. Are you all needing to be heard? Okay, with that, I do think that there is an opportunity for improvement, because sometimes these applications will, take many years and morph over time. And sometimes, having an understanding of how the applicant is envisioning how they navigate many of the changes we have incorporated in our comp plan, in our urban planning or our rural planning. A lot of those things do impact projects sometimes, and I think there's an opportunity. But I do believe that we do need to tread carefully in making sure that we understand what's possible, how to make sure that that conversation or that information that's been shared with an elected person is documented in some way, so that there is, as was mentioned earlier about, you indicate that you've spoken to either the applicant or the constituent or those kinds of things. So I think maybe there's a process we could consider in order to improve communications and get the goals of our land use comp plan, and community growth goals achieved. So with that, not seeing any other hands, I'd like to hear from Ms. Lundgren, and maybe she could give us some good guidance on the conversation we just had. So thank you. You're recognized.
Thank you. And I think Adam, Mr. Gormly did a great job of outlining the applicable standards regarding the procedural due process that applies, the standards of procedural due process that applies to quasi-judicial hearings under Florida law, rezonings are subject to fairly precise requirements based on history of case law over the past few decades. In early 1990s, the Jennings case gave the legal guidance on ex parte communications and basically stated that those are considered to be presumptively prejudicial. And the legislature several years later responded with the statute 286.0115 that allows local governments and land use procedures and quasi-judicial land use procedures to basically open up the ability for ex parte communications, provided that the local government adopts a prescribed process via ordinance or resolution. So it is a possibility. The reason that we've been operating the way we have is based on the case law, and the statute does allow that opportunity should there be a direction to do so. But in any case, and the statute does contain this statement that all decisions of the decision-making body in a quasi-judicial proceeding on local government land use matters must be supported by substantial competent evidence in the record pertinent to the proceeding, irrespective of such ex parte communications. So regardless of the presence of such communications, it will be incumbent upon the board to remain within the record of the proceeding and make its decision based on what has been established.
It has been established within the application and within the record, just to clarify.
Within whatever the record may be, whether that's in a zoning hearing master case, such as a rezoning, or in a minor modification, the record that's established in that case. It is a standard, basically, of adhering to the legal requirements for the evidence to be in the record, the testimony, the staff reports, both types of applications that the board hears on rezonings would be subject to that, even if ex parte communications are allowed.
Okay, thank you very much for that clarification. Commissioner Smith, you're recognized.
Thank you. Moving to a whole other thing besides the ex parte, it is this whole edifice of the zoning hearing master for just some, as we heard and saw yesterday, some rezoning applications have to go to zoning hearing master, not all of them. And so I would like us to consider, I mean, look, our process with the zoning hearing master and everything is very complex and unique. It is clearly not perfect. Can you hear me? Yes, okay. It's clearly not perfect. Just ask our citizens and look around. I think it's high time for a review of this complicated system and consideration of how we can improve it. This way has not resulted in smart growth. It's not resulted in small walkable, bikeable town centers throughout the county. It has really, resulted in a mess, even beyond the issues of not being able to have concurrent infrastructure, roads, schools, fire, water, all of that. But even past that, it would be hard to argue that we, that this way of doing things can't stand any improvement. The zoning hearing master piece of this process is very complex, and as noted before, it's not universal. In fact, when I first got here, my staff and I looked around at other municipalities and made a spreadsheet of what other counties and cities are doing. You know, the city of Tampa does not do this, but other counties do not do this zoning hearing master step either. And there's a lot of, you know, there may be some pros to it, but there's certainly cons. The process, the zoning hearing master, you know, doesn't have to be a lawyer. And in fact, one that we recently left was just an engineer whose whose clients included some of the developers that came before him, and whose opinions conflicted with the director of the planning commission and this board. I mean, there's nothing that makes the zoning hearing master's opinion any more expert than any other citizen. Often the neighbors have more on the ground knowledge of drainage, traffic, compatibility. Certainly our planners do. And this process sets up the zoning hearing master as some expert. It makes it harder to defend the county commission decisions if they conflict with the zoning hearing master, because we've set up this, you know, kind of Wizard of Oz that weighs in along with our planners and our own transportation experts and the citizens. So, you know, I just think that this is definitely worth a look too, whether we might consider eliminating that or streamlining it in a way. If there's some value in having this initial hearing to package stuff up, at least streamline it and not have the zoning hearing master add another opinion, because the zoning hearing master is mainly just summarizing everything from all the other reviews, but giving that zoning hearing master title, it has an air of authority really greater than or on a par with the board, but it's really our board decision that is the ultimate authority, and we shouldn't have to compete with this zoning hearing master's opinion. But beyond that, you know, this whole process of 2 hearings, it just makes the citizens, the applicants, the staff go through 2 hearings that other municipalities do not require. And in fact, we don't require it for the minor modifications and PRSs and consent agenda. Well, no, the consent agenda has gone. But anyway, a lot of things people do just come to the board. On everything, the final decision is made by the county commission. So it would make it a lot simpler to defend the county commission decisions in court when they're challenged if we don't have this other thing. And finally, you know, the other problem with this zoning hearing master thing is, and maybe, you know, this is an aspect that could be eliminated or fixed without eliminating the zoning hearing master. I'm just putting out these aspects of this that I find troubling that we should look at revising. This whole aspect of establishing the record ahead of the county commission hearing so that nothing can come to us except what is already packaged up at the zoning hearing, which is at least 2 or 3 weeks ahead of our hearing, is excruciatingly problematic for us and for the citizens, at least. Certainly the land use attorneys, they know their way around, and maybe some of complexity works for them. But it makes it very difficult for us, as Adam pointed out, or Mr. Gormly pointed out, request for additional evidence is almost always denied. They have to prove, a citizen has to show that what they want to show their elected officials at the county commission could not have been presented 2 or 3 weeks or 6 weeks earlier at the zoning hearing. Maybe just now they've taken a picture of the rain piling up on their street and they've got a flooding issue that they want to show. Maybe they've just now gotten access to a computer where they could screen cap a map they want to show us of their neighborhood, but they can't if they didn't show it to the zoning hearing. Maybe they don't even know they're supposed to show stuff to the zoning hearing master before they can show it to us, and that happens a lot. So I think that's really, really cumbersome. And then when they get to the county commission, their citizen testimony is much too often interrupted by picky questions. And I understand our county attorney is simply carrying out this process. So I don't mean to blame the attorney for this, but I think we should change the process so that citizens are not prevented from saying anything to the county commission that was not said at the zoning hearing. I mean, that has become interpreted to be like recently somebody who was talking about the issue of a new commercial use. I think it was a 7-Eleven in rural area of Lutz. They were talking about the threat of light pollution. Well, they were interrupted because even though lighting was discussed at the zoning hearing, the phrase light pollution was not said. And besides, to my mind, any discussion of lighting or light pollution goes to matters of compatibility to the neighborhood in the rural area. People expect night skies dark enough to enjoy the stars in a rural area. But this business of, well, you can only say exactly what was said at the zoning hearing, master hearing, is really got to be loosened up, in my view, to allow us to have a full picture and allow people to come to us the final hearing and show things, whether or not it was physically possible or to have shown it, if only they knew the rules, to the zoning hearing master. I mean, I think that's really got to be lightened up so that we can make the best decision based on the best information. I think we should consider not tying it all down to some initial hearing. But honestly, when citizens go to the zoning hearing, master hearing, they feel like they've gone and been heard, and they don't have the bandwidth to do a second hearing, so they don't come to us. They get tired out, and then they see the zoning hearing master is just, oftentimes just summarizing what's been said. It looks too daunting. I think we should allow our citizens to come straight to us, say whatever they want to say, and show whatever they want to show. We are the elected officials. We're the final authority, and we should be more accessible to the citizens in these matters. So I hope that in future, as we move forward from this first step discussion, which I'm really glad we're beginning, that's something we can look at, wholesale elimination to some kind of streamlining and loosening of that zoning hearing master process. Thank you.
Thank you, Commissioner Smith. Commissioner White, you're recognized.
Thank you. I agree with everything that Commissioner Smith just said, and I've brought up this relevant statute as we've been talking I mean, it talks about site visits by commissioners. So presumably under our current process, there might be a problem if a commissioner decides to get in his or her car and just take a drive around the community and drive around the subject site and just take a look at things. And, adopting an ordinance or resolution that would allow for the ex parte communication, I think would just resolve so many of these issues. Ditto to what Commissioner Smith said about how people try to present information or evidence to the board at the meeting, and it's disallowed because they can't find anything in the record that it's been before the zoning hearing master. I agree wholeheartedly with Commissioner Smith. We might be coming out of a 1 month dry period, and we finally get some heavy rain so that a constituent's able to take pictures or video of flooding or that sort of thing. There's the whole issue of them, just not knowing about the rules of this cumbersome process. And I know the old adage that ignorance of the law is no excuse, but come on, we're people's duly elected officials, and they have a reasonable expectation that they should be able to come to us and present information. So what I'd like to ask, Madam Chair, is, I can see that the board is a bit divided on this issue. I'd say there's a good chance that it's 4-3 in either direction. But Madam Chair, I want to ask if you see enough consensus to ask staff to start the process of bringing something to the board for its consideration, to do all the necessary work for an ordinance or resolution to include drafting, thinking about any applicable public hearings, that sort of thing. If you feel comfortable asking for that today, I'd like to see that, but if not, I'd be willing to schedule a commissioner item for the next land use item that would ask the board to direct staff to start some work for the board. Presumably a resolution could just be done, with language drafting and just come to the board for a simple vote. An ordinance, I know would trigger public hearings, and I'd be fine with the ordinance route. I mean, public hearings would be fine with me, but I guess the point there, I'm probably splitting hairs here, but there could be multiple pieces of work that staff would have to take on, above and beyond drafting. They might have to think about asking the board to set public hearings and things like that. But I'd certainly like to see something come to the board for its consideration.
Thank you, Commissioner White. And we'll get there in just a second. I want to make sure I hear from all the board members on this particular item before I offer my my observations of this. Commissioner Kemp, you're recognized.
Well, I also am very pleased to have this discussion, having 5 years under this process. And again, I've watched other communities meet, so you can't tell from necessarily what you see at the meetings, but I know that there are other possibilities, and it seems like other communities, for the most part, have a different process. I think that eliminating the ZHM worries some, that our meetings would be the only opportunity kind of for vetting, and actually what it does is kind of narrow the record, but in some ways that, as we've said, has not, the rainy season is especially something that, we know can be a problem. But I mean, there's all kinds of problems that people discover new issues between the zoning hearing master and the board. But I really find that and I find it helpful, Commissioner Smith, just like yesterday when you pointed out the different parts of the agenda and said, see, the sky hasn't fallen here. We're not deluged with, we haven't been deluged with all kinds of problems ever since we didn't when you had to file after the zoning hearing master's decision, but before 10 days before, people, it's just unbelievable. Actually, I think that rule existed for how punishing it was on the community if they had any input to any land use decision. I do think the requirements that we make on the public are so onerous and so difficult that we make it too, we do not hear from the community and do not get a full picture because of the way that we engage. And I also think not only do they have, it's just, I don't even, again, we had one of the slides show that when the signs go up, it said, if the language on the slide was, if a member of the public, and I thought I wrote it down. Yeah. If the sign is up and a member of the public, they have a meeting if requested. So that's like if somebody calls a developer and requests a meeting, and I'm sure the first thing they get is engagement. This isn't always bad or nefarious, but engagement by the developer. But so maybe they did request a meeting, and I mean, we don't even know, but first of all, they have to in some way request it. It's not just automatically set up. The developer has an opportunity at this meeting to give their side or engage, but there's like no staff. They're saying, well, maybe that's not accurate, or kind of fending for the community, or at least giving a balance there at that meeting. And that's not even any kind of official meeting. Then they have to know that they might want to go to the planning commission. They must go to the zoning hearing master. And I think many people by then would think that there's nothing else to do, quite frankly. I mean, I really think the place, as Commissioner Smith says, for it all to land is wholly and fully before the county commission. And I'd be very much, up for looking at other ways, whether it be really reducing that role or just, landing these at the county commission. And again, I'm just looking at the way other communities do it. And I feel like our barriers are giant walls for any community engagement. And I feel like we have too few opportunities just in general for the community to engage in the issues that they most care about, which is their built environment, transportation issues, and the kinds of things that affect their quality of life when their neighborhoods or communities are impacted in such a heavy way, or to express, what they would want. We no longer, there was a time, I think, when we had more of that, to tell you the truth. Back when I was an aide, we did have quarterly town hall meetings, and a lot of this came up. But the way for the community to speak to these things is too cumbersome, and I'm all for reviewing and looking at what other places are doing and how we can change or modify what we're doing to, again, bring more of this forward to the board.
Thank you, Commissioner Kemp. Commissioner Cohen, you're recognized, and then I'm going to offer some of my opinion before I acknowledge Commissioner Smith, if you don't mind. Commissioner Cohen.
Thank you. And let me just be clear that I'm going to be open-minded about all of the suggestions that come up and be thoughtful about them. The issue of ex parte communications is different than some of the issues that Commissioner Smith brought up later in the conversation. And I think that the issue of opportunity for public comment definitely is one that we ought to explore, because there's no question that there have to be opportunities for the public to speak. And if they speak on things that are irrelevant to the record, then commissioners have to ferret that out when they're listening to what people have to say. But I do want to just raise one practical consideration, and that is that there's going to have to be a hearing conducted at some point in the process, no matter what we do. And I do wonder if the board were to take back additional authority, if we were to eliminate zoning hearing masters, I wonder from a practical point of view, how the board would actually get its work done along with all of the other responsibilities that we have. I think that's a really important factor to consider in all this. The second thing I just want to say about the zoning hearing masters, who are ideally appointed by the boards, they ought to be people that we have confidence in, and perhaps we'll look at that as we move along. But I appreciate the fact that when we go into these cases, we have three sort of legs of the stool that have given us their professional judgment on the matter. And I find that in our meetings, when there's disagreement of the three legs of the stool, it tends to spark the most interesting discussion among the board. And there's certainly no shortage of cases where the board disagrees in one way or another with some of these findings. So, I just think that we ought to be deliberate in looking at the way we do this. And then the final thing I would say is that, you might be able to just add public comment into our process without upending the whole system. It might be as simple as simply allowing people to come and speak during a public comment segment of the meeting. I'm not sure that alone can't be considered as one way to sort of break open the access for people without necessarily, increasing the number of hearings we do to a point where I think we're overwhelmed. So I just wanted to add those few comments. But again, I'm happy to hear what everyone has to say and what different ideas are out there on this.
Thank you, Commissioner Cohen. I'm listening to the two different issues. How do we go about not, violating an ex parte communication, but also at the same time in the process, make sure all the fairness, all the information, is available.
County Commissioners.
We have someone speaking at the same time.
Florida. Thank you.
Okay. No, I think that was communications testing to make sure we're all here. But as I was saying, I think there's an opportunity for us to work with, the land use team, the development team, and our legal team to work with us and our citizens and our, professionals that are in the industry to make sure that we're getting all the information necessary to make the best decision that's on behalf of the community, because that's our job, right? So we're looking to try and figure out a way to do that. To Commissioner Cohen's point about if everything comes to the Board of County Commission, we may find ourselves with a very, very long agenda that's similar to the city council meetings that go into the middle of the night. And I'm not sure any of us are up for that experience. If the zoning hearing master process does bring, 90% of all of the issues to the table and documents that's there, but we still leave some time at our presentation to say, yes, we've heard from the citizens and we've heard from the applicant, and yes, these are all the information we've heard. Are there elements of what was presented through a zoning hearing master process that have not been fully explored or advocated on behalf of the citizens and or the applicant, or the planning commission, or or our land use folks that need to be considered by the commissioners so that we can make the best decision for our community? there's got to be a way to do this that we can do within the law, within the quasi-judicial nature of these hearings, as well as within the statutes is available to us. So to hear, all the commissioners' comments here, I agree there's a way to do this, and look forward to having our staff bring back some ideas that we can further explore and then actually adopt either by ordinance or resolution to simplify the process to ensure that all the relative information that we need as commissioners to make a decision and vote on a decision that's in the best interest of Hillsborough County is possible. I think we can't get there. So I look forward to working with the staff and our legal team, as well as, even just observe where we've seen zoning hearing masters information come forward that was really relevant and very effective at giving us all the information. And maybe not have them rule, but have them ferret out and make sure all the information is available so that when we are briefed prior to a public hearing that we receive, all the information that's available from the applicant and the citizens and the zoning hearing masters. Due diligence is rather where I'd go with what the zoning hearing master's role would provide us in terms of gathering all the information as much as possible without having such a long timeline between when that ruling is made or that observation is made or hearing information is made. And then also allow, as Commissioner Cohen mentioned, some public comment that actually becomes relevant possibly between the two or was just not available at the zoning hearing master's point. So I look forward to getting there, because I do believe that there's an opportunity to do it better, because I believe there's also been times where we have not been given all the important information that is in our communities and our county's best interest. And it's just because of the process more than anything else, not because we were, trying to keep somebody from saying what they needed to be said. So with that, I'm going to offer Commissioner Smith an opportunity to also speak. You're recognized.
Thank you. And just in wrapping up, I'm really excited about having these conversations with each other, with staff, with the board. I am hopeful that we can take a serious look at this process and consider improving it. And to that end, I would suggest that the next time we maybe have a workshop like this, or a commissioner or staff brings forward something as Commissioner White suggested, that it would include in the backup kind of an overview, a spreadsheet of what other jurisdictions do. So everybody can see that there are a myriad, wide spectrum of ways to do this, and that is being done successfully in other places. And we, can consider maybe not reinventing the wheel. But I'll offer to send Mr. Gormly and Ms. Lundgren the spreadsheet that we compiled in my office of a wide range of jurisdictions, ways of doing this to start from. I'll also say there's this conception that I've heard as I've been discussing this, that there's the one benefit of the zoning hearing master process and hearing is that packages the information and collects all the information and packages up the record in a way that saves us a step somehow. If you've ever been to a zoning hearing master hearing or think about the process, what actually happens is our planners and our transportation planners, our water department, our school district, they all provide their reviews, their pieces of the puzzle ahead of time into this package. And Planning Commission finding, development services planners, our experts make their findings. And so you have those two findings that and recommendations. And then, you know, that goes to the zoning hearing master. Some citizens can speak there. But again, that's an extra step for citizens who will also have to speak to us if they want to have their comments considered. Citizens can provide written information to the planners at any point when the yellow signs go up. They can call, they can provide written testimony. Their input can be part of that package. And then that goes to the zoning hearing master. And the record is sealed. The gavel goes down, boom. Now, I'm going to stop my video. So what has gone to the zoning hearing master now doesn't get processed in any other way except for the zoning hearing master to add one more guy's or gal's opinion, one more person's opinion to the mix. And as I say, they're not in many ways as expert as our planners who have already, and our reviewing agencies, our transportation engineers, our water engineers have already added. So this zoning hearing master opinion that gets added there is about the only other thing that gets put in the package before it comes to us. That whole package is presented to the zoning hearing master in the same way that it's presented to us in any of the E items on our agenda. And we get the planning commission recommendations, we get our development services recommendations, and we see any other, the EPC comments about wetlands. That's all in the package, whether it goes to the zoning hearing master first or comes to us. The only thing added at the zoning hearing master is, you know, the zoning hearing master's opinion. And as I say, I think that becomes very cumbersome, and the process of two hearings itself is very, very cumbersome. But, you know, if we were to have another workshop, you know, I think it would be fruitful to really look at what does the zoning hearing master bring to the table, and how should we consider their recommendation? How much weight should we really be given this extra opinion? And similarly, I would like to, you know, have some discussion of what the planning commission actually does and what they might do. I wonder sometimes if we're really using our planners at the planning commission. They're experts. They study this. They go to conferences. And I wonder if we're really using their expertise to the full extent that we might be, when the process has, I think, kind of reduced them to looking at the specific language in the comprehensive plan and seeing, is there a conflict? Is it consistent? Is there any language here? Is the locational criteria, say 900 feet away from whatever, does that include a daycare? Or are they able to use their actual planning background in a more expanded way to help us benefit from that? And a paradigm case of that, to my mind, was a case we had of a zoning for 1,500 houses outside of Balm in the rural area on 40-foot wide lots, when the Balm community plan clearly said goal one was to have an eclectic mix of housing types in their neighborhood, to develop of a piece with Balm, where every house is kind of different and they're on large lots. And here came 1,500 houses on 40-foot lots, 40-foot wide lots, 4,000 square foot big. And the only design standard was that the driveways would alternate from the left side to the right side, to the left side, to the right side. And the planners found that consistent because the letter of the law, the letter of the Baum Community Plan did not specify 40-foot wide lots or 100-foot wide lots or anything at that time. Now we fixed that, but I would like to see if we can, improve this process to allow our planners to have a little bit more leeway in their input. I think that would be more beneficial than any zoning hearing master's opinion. And by the way, the zoning hearing master is also restricted to looking at just what the planners and traffic engineers and water engineers have said in the record. And then he makes or she makes an opinion based on that. It's not like they bring something extra to the table and say, in my vast experience as a planner, I just don't think this fits in, or I think it should be adjusted. So, I think we should really, now that we've had a look at the nuts and bolts of our zoning process, begin also thinking about, how these pieces inform us and influence and weigh on our final decision. So
thank you, Commissioner Smith. I appreciate those. I appreciate those observations. And one of the things that I wanted to talk about today, and it works in concert with what we are discussing. When we all have worked very hard on updating and our comprehensive plan, and we have great planners doing great work, and we have great, land development code and the zoning hearing minister that is reading our code. When there's a disconnect between the two, in other words, we haven't necessarily fully vetted out our land code to match our comprehensive plan goals, or applied our comprehensive plan goals and standards and in line with our growth strategies, our community strategies, our economic development strategies, our mobility goals and standards. When the land code hasn't been modified to address that, is where we find I believe the commissioners are having to reconcile that, and it does make it sometimes difficult to seem as though we're listening to all parties. And I think that's an important thing that we need to continue working on. I know that our land code is oftentimes, one size fits all in some respects, whereas our comprehensive planning is just discerning that there is a need for different types of land code for highly urbanized areas, somewhat urbanized areas, transitioning suburban areas, and rural areas, and how that gets managed, so that we are being very smart about where we grow and impact our infrastructure. So I think there is a way to get where we need to go, but having all the information at the point where we're making decisions for a specific applicant, I think, is critically important. And with that, I see Commissioner Cohen has his hand raised, although he turned off his camera. So I just want to
take it down. Sorry about that.
Okay, I just wanted to recognize you if you were interested. And so what I'm hearing is there's an opportunity for us to take a look at not only our process, but where we can facilitating making sure that the commissioners have the information they need without violating a quasi-judicial, circumstance, or making sure that we get the information as projects do evolve to address some of the changes that we've created in our own comprehensive planning and land code. And they're looking for opportunities for achieving, the goals for both themselves, but also within what the community really wants in their area, in line with their community plans if they have one, but also in line with what we've described to that community as our goals in our comprehensive plan. I'm not seeing any other hands. And so if Mr. Gormly or Ms. Lundgren, would you like to offer some guidance on on what you've heard so far that you see as a good process for moving to the next step. And then Commissioner Kemp, I'll recognize you after we've heard from them.
So, commissioners, I think what I would propose is I've heard the various discussions on the potential for ex parte communication being addressed through an ordinance or resolution, the zoning hearing master process, either whether that process is the appropriate one to have, or whether the structure of limiting testimony to the record established there is the appropriate to have. So I would propose is that come back to the board, perhaps at a land use meeting where action or direction could be taken or given, and with an outline of potential changes to what we have now could be considered, both on the zoning hearing master process itself, the record limitation, ex parte communications, and present the board with some options to provide direction on that we could then take and incorporate into the appropriate amendment process. In that we would could also bring back some information on what other jurisdictions are doing in terms of the process has been mentioned here to aid the board's consideration of this matter. If that would be an appropriate way to move from this, that's what I would offer.
Excellent. I appreciate that recommendation. I heard that too, and so I think you're on point, Mr. Gormly. Ms. Lundgren, would you like to offer some feedback, and then I'll recognize Commissioner Kemp. We can't hear you.
Thank you, commissioners, and I concur with Mr. Gormly as far as his recommendation to bring these options back to the board at a land use meeting where potentially action could be directed. I'm certainly able to partner with Mr. Gormly in preparing for that meeting and advising on desired changes and preparing for that with any legal recommendations and guidance on the process.
Excellent. Thank you very much. And I see that Melissa Zornita is actually on the call. I was curious if she might have some thoughts to offer us, as she has heard what's been spoken about today and the Planning Commission's role in this process, and any suggestions or advice going forward to the next step.
Thank you, commissioners. Melissa Zornito, Planning Commission Executive Director, for the record. I don't have any specific recommendations at this time. I think the conversation has covered a lot of really interesting ideas. I appreciate the discussion about our role in the process and how our review at this point is contained to consistency with the adopted comprehensive plan. And I do know that the planners here have ideas that are beyond the adopted comprehensive plan. My guidance to them has always been, well, we need to update the comprehensive plan to incorporate those ideas so that then they can be included in our reviews. I still think that's probably the cleanest process, but if there are opportunities for us to continue partnering with development services, we have a great relationship, and my team meets a lot with Adam's staff on these different rezonings, trying to work through the issues and bring forward projects that we all can be proud of. That's all I have at this time. Thank you.
Excellent. Thank you. Sorry for not giving you notice that I was going to call on you, but we've talked about the issues associated with what we as leaders are looking to try and accomplish, and how we grow and how we serve our citizens well, and how that intersection between, housing, economic development, road infrastructure, and all of those things that we're asked to make decisions on, and they all play a big part. And there's the planning part, and then there's the implementation part, and we get asked to try and make decisions along those way in both elements. So I appreciate the team working together. Commissioner Kemp, you're recognized.
And I'll just quickly make this point, and I think it wasn't made because it's so inherently recognized by us all that we didn't really speak to it. And it's part of the process and a necessary part of it that sometimes these huge developers or people making these plans that impact our neighborhoods and communities in such a big way that they have big paid staffs of lawyers, of other experts and planners that meet with our staff and our planners, and they have a lot of access to them. And then when we have these hearings or neighborhood meetings or anything, they have very big resources to send out teams, if it has to be, of lawyers or whomever else, to really kind of overwhelm communities. When all these processes go through, they actually make money when they have to sit at a zoning hearing master meeting for hours and hours on end and prepare for it and go up to county center and whatever. But for citizens that are trying to engage in the process, the opposite is true. They have to take their free time that they have. They have to take off work sometimes, lose wages, and really make great sacrifices to be part of the process at all, to have their issue heard. So it's a major equity issue, and I'll just say that the more time that we can let, and the more access that we can let people have to the commissioners and to the process, that builds equity into the process, which I think is really important.
Excellent. Thank you for making that point. Okay, I'm not seeing any other hands raised. I believe our staff has excellent guidance on how to bring back something, or we'll work with within a land use meeting for adopting some steps that may best serve not only our goals and requirements for land use development, but also the ability to actually move in a good positive direction. So with that, not seeing any other hands raised, and I think the staff has heard where we want to go.
Yes.
I'll just call this workshop closed. Thank you very, very much.
Thank you very much, Commissioners.